Alahousas?
Here.
Mr. Boris?
Here.
Mr. Elliott?
Here.
Mr. Roboski?
Here.
And Mr. Hess?
Here. At a request of one of the members, we're going to hold the minutes off till after we take care of the business at hand. So anybody would like to speak tonight, would you
Mr.
please
Chair?
stand up and raise your right hand and be
Mr.
sworn
Chair,
in?
I do have the quasi-judicial announcement.
I'm sorry?
I have the quasi-judicial announcement and do the swearing in.
It's number 2.
It's number 2 on the agenda.
She's got to do that.
Yeah, I think I just asked that. Oh, I'm sorry, no, I did miss something. Go ahead.
The matters before the City of Tarpon Springs Board of Adjustment are quasi-judicial in nature. In a quasi-judicial proceeding, the board's function is to make findings of fact based upon the evidence presented at the hearing and apply those findings of fact to previously established criteria contained in the City of Tarpon Springs Code of Ordinances. This is a legal decision regarding the application before the board. The board may only consider evidence that the law considers competent, substantial, and relevant to the issues arising from the application and the applicable code sections. If the evidence demonstrates that the applicant has met the criteria established in the Code of Ordinances, the board is required by law to find in favor of the applicant. If the evidence demonstrates that the applicant has failed to meet the criteria established by the Board of Commissioners and the Code of Ordinances, then the board is required by law to find against the applicant. Any and all persons providing testimony at this hearing are required to do so under oath. All persons testifying at this hearing must give their name, address, and must indicate whether or not they have been sworn for the record prior to proceeding with their testimony. All testimony and questioning at this hearing must address matters that are relevant and material to the issues under consideration based on the criteria established in the City of Tarpon Springs Code of Ordinances. The following is the established procedure which will be followed at this quasi-judicial hearing. First, city staff will present its testimony and evidence regarding the application. The applicant will then have an opportunity to ask questions and cross-examine the city staff and any city witnesses. The applicant will then have the opportunity to present its witnesses and evidence. The city will have the opportunity to cross-examine the applicant and any of the applicant's witnesses. Members of the public opposing the application will be given the opportunity to present their testimony and evidence. Each person will be given 2 minutes to provide their testimony and evidence. Members of the public in support of the application will be given the opportunity to provide their testimony and evidence and will have 2 minutes for such presentation. The applicant may present any rebuttal testimony and evidence in a closing statement for summary. The city will present any rebuttal testimony and evidence and/or a closing statement for their summary. The chairperson will then close the public hearing for consideration by the board. At this time, any individuals here to speak on this matter, please stand and raise your right hand. Do you swear to tell the truth on the matters before the Tarpon Springs Board of Adjustment this evening? Okay. When you come up to give your testimony, please speak clearly into the microphone, state that you've been sworn, and give your name and address for the record. Thank you.
Okay, thank you. Okay, we have application 15-43. Would the staff enlighten us, please?
Sure. Good evening, everyone. Heather, and I have been sworn. Heather Ruler for the Planning Department. The request is for a 1-foot reduction to a required side yard setback in the R100 district. The property is located, it is lot 41 in the Gulf Beach Park subdivision and is located on the south side of Gulf Beach Boulevard. The application was originally submitted as a de minimis variance request. Staff did review it as such and received 2 letters of objection as part of that process. That being the case, they both came from the adjoining neighbors, and so the applicant chose, under staff's, gave them the option rather than denying the application to come to this board and address their concerns directly to this board. That being the case, they chose to do that, so we transferred the application. It was re-notarized, and there was a legal ad put in the paper for this particular hearing on this particular application. Essentially what this is the lot width of this particular property is 60 foot. 75 foot is what's required. It's considered standard lot or minimum lot width for R100. However, this lot was platted in 1925, long before those standards were implemented. That being the case, it's a legally non-conforming lot. The requested variance is consistent with the variance criteria, and the applicant would like to place a 36-foot wide single-family home on the property. With that, staff is recommending approval of the variance with no conditions. And the objection letters that were received as part of the de minimis variance are actually part of the backup. I included that information so that you were aware of that information as well in the backup. With that, I can answer any questions.
Is that, anybody on the board have any questions?
Do you tender your report and the city's file on this matter into evidence for the purposes of this hearing?
Yes, I do.
Thank you.
Okay, would the applicant please come forward and state your case?
Hi, everybody. I'm Drew Labriola, 1611 Mexico Avenue in Tarpon Springs. We're the ones who put the application in, along with Ray. He's the owner of the lot. We're trying to purchase the lot. The house we're trying to build is literally 36 foot wide on a 60-foot. They say you need 25 feet, so we're looking for 6 inches either side, so basically the size of my hand on either side of the house. That's it. So I really got nothing more to say than that. I don't know what to say. It's just that's all we're looking for. Any questions?
I just want to make a statement that the applicants are friends of mine. We haven't talked about this at all. They probably didn't even know I was on the board.
Didn't.
And they're not my clients, certainly, and my vote is not going to be based whatsoever on friendship or lack of friendship, or line calls, or bad line calls, or good line calls.
Exactly.
I have a question.
Mm-hmm.
We're talking about 6 inches on each side.
That is
Is
correct.
there any kind of an amendment in the books where if it's under a foot or something like that, they don't have to come before a board or anything?
They passed you this right here with an arrow.
I see, okay. Sorry.
Is that it? Thank you.
I do have a question for staff. Not for you, sir. Thank you. You know, I see some other lots here that are 60 with structures on them. They obviously got variances as well, right?
Well, not all of them receive variances. Some of those houses are less than what this request is, which is for a 36-foot wide house. Some of those houses are less than 36 foot, so they didn't require variances. But many of the houses in this subdivision use 2 lots so that they could have a wider home on.
Right.
In this case, this lot is developed on either side. There is no way to
Right, I
acquire
know.
additional properties. So this is a minimum variance by all definitions of what a minimum variance is.
Right.
So, but you are correct. There are homes on 60-foot lots in this subdivision that were built either without a variance because they were built as smaller or they received a variance.
Okay. Thank you.
Anybody else have any questions?
Yeah, just, Heather, on that point, I happen to be the person who wrote this ordinance in question, the de minimis ordinance, section N, what we're looking at for us tonight. And in fact, it was my suggestion that the city pass that ordinance. And the way I understand it, Heather, and correct me if I'm wrong, the 5% figure, if there's a 25-foot setback requirement total, and this is 1 foot, so that's 4%, which is less than 10%. Is that how you understand it?
That is correct,
Okay,
yes.
thank you.
Anybody else? Okay, anybody in favor of this, you please come to the podium and
Hi, good evening. My name is Ray Strauss. This is 300 Shore Drive in Tarpon. We own the lot, my wife and myself. When we purchased it 14 years ago, prior to the purchase, we were concerned about the same issue. We knew we could only build a 35-foot wide house. We went to the building department. They explained to us. We asked if we could get an additional couple of feet. They said, most likely you can get it. So we went ahead and purchased it. It's 14 years later, here we are. So we're the sellers. Those are old neighbors of ours, and they're interested in purchasing it. So, and like you just mentioned, I know there are other homes in the neighborhood on similar type lots, and we hope he passes tonight. Thank you.
Anybody have any questions, any more questions? Okay, how about anybody opposed to this motion? I shouldn't say this motion, this application. Okay, well, if there's no more questions, then we're open to discussion here on the board.
If I'm in order,
question.
oh, I'm sorry, go ahead.
Go ahead. I have a question to ask the staff. And my question is, when the 100 zoning was established in the neighborhood? Do we know?
The R100 zoning, I've done a little bit of research on that for some of the other variances that you've had, and I've gone back as far as prior to your 1990 ordinance. There was an ordinance in the late 70s. R100 was in there, and some of the standards were similar there. I have not specifically looked to see if the setback was addressed as part of that ordinance. I would assume it was, and that's something that if you're interested in finding out, I can certainly do that
No.
research.
The point, excuse me, go ahead.
I know the answer if you want.
No, I just want to make a point that the zoning was actually established way after the law was plotted back in 1925.
That is
So
correct.
that is a non-conforming lot on record.
That is correct.
I don't know much, but I do know the legal history of Tarpon Springs. There's Ordinance 799, passed in 1976, which created R100 zoning and a 75-foot minimum lot width requirement.
So it was the 70 ordinance.
Anybody else? Nobody else has a question, we're,
If I'm in order, then I'd like to make a motion the variance be approved as requested.
Second.
I second it.
the motion's been made and seconded. Call for a vote, please.
Mr. Alahouzes?
Yes.
Mr. Boris?
Yes.
Mr. Elliott?
Yes.
Mr. Roboski?
Yes.
Mr. Hess?
Yes. Okay, thank you very much. That, the application
It's finished.
15-47 has been approved. Thank you very much. Now,
Very glad you're going to be investing in Tarpon Springs. Thank you. On behalf of the city, we appreciate it. Thank you.
I'd like to point out something on this
Oh.
application. That's on this paper, it says 15-43, but on the
She works at Charlie.
the
front
agenda,
page, it says 15-47. Do we know which the actual number is?
It's 43. That should have been corrected. I wasn't given.
I'm just working in advance. I mean,
So it is in fact
It is in-
43, not 47.
Correct.
All right. Thank you.
I apologize for that.
we are. Okay, so we are now up to the minutes. We have, what do I do with our minutes here? We have minutes for March 25th. Anybody can look over them and have any questions or?
I've been
Mr.
talking
Elliott?
too much tonight. I'll defer to anybody else who wants to bring up the minutes. No? No?
I have no questions on that. No comments either.
Oh, you don't have anything to say?
No, I do.
Oh, okay, go ahead.
Okay. First of all, we're doing March and April. Are we doing them together or separately?
I was going to do them separate.
Okay. I hope that we're a month behind. I hope that we're going to get caught up on approving the minutes for our next meeting, you think, Heather? Is it
We're catching up, but we still
still,
are,
be nice to have the
Be nice
minutes
to
of the
have
prior
last
meeting
month's.
that we're looking at.
Yes, it would.
So if we can do that. But anyway, as far as on item number 4, I think it's on page 3. Talking about this is that variance that was on Shore Drive in Tallahassee, right near where we did it tonight. Side yard setback 1.5 feet. Was it a 1.5 foot setback? I don't think so.
no, I don't think so. That was 15 feet.
15 feet.
I'm
Is that
pretty
right?
sure.
I think it was a 10-foot variance, as I recall, on the side. So we can correct that. And then the board...
Heather, do you know the answer to that question?
I wasn't working for the city
Oh.
at that time, so unfortunately, I can't speak to either one of these minutes because
As
I
I
wasn't
recall,
part
it was
of.
15 feet too, also.
Okay, well, let's
of that.
double check. Then, in the board comments, on that item, it says I spoke to Mr. Young. I don't know who that is, but Mr. Huffman was the person I spoke to. Bruce Huffman. And that's all I have on that particular month. Thank you, Chairman.
So on that particular set of minutes, the March 25th, it would be a motion to approve as amended by Mr. Elliott. Whoever would want to make that motion and second it.
So moved.
Okay.
We have a motion, do we need a second?
Second.
We have a motion and a second to approve these minutes as, with the
Spoke to.
the change that Mr. Elliott found.
There's a disclaimer he put on.
We have a roll call, please.
Mr. Alahouzes?
Yes.
Mr. Boris?
Yes.
Mr. Elliott?
Yes.
Should be Huffman
Mr.
Young.
Roboski?
Yes.
Mr. Hassett?
Yes. Okay, this is, next one is April 22nd. I was not at that meeting. We do, the rest of the members here were, so we, any discussion on that? Go ahead.
My turn? For item number 3 on the factless variance on page 2, if you recall, the first meeting, the one in March, I thought I had a conflict of interest and I did not vote. And then I want to make it clear in the minutes that upon reflection and some legal research and talking to the city attorney's office, that I did not have a conflict, and by law I had to vote since I'm here. So I want the minutes to reflect that I did not have a conflict and I was going to vote on that particular application. And then on the next page, I mentioned kind of 2/3 of the way down, a fence and encroaches on the property. The fence actually encroached in the right-of-way adjacent to the property. Oh, I see here it says Mr. Cooper was his name. Thank you very much.
Okay, any other questions? Do we have that information that you need, the secretary? Okay. Okay, we have a motion for approval.
Motion to approve with the adjustments made by Mr.
I
Elliott.
second it.
This moves. Motion's been made for approval and seconded. We have a roll call, please.
Mr. Alahouzes?
Yes.
Mr. Boris?
Yes.
Mr. Elliott?
Yes.
Mr. Roboski?
Yes.
Mr. Hassett?
Yes. Okay. Now we're up to staff comments and from the staff and board comments. I might as well start it off. I see you'll notice that Matt King is not here. His term has expired, and he chose not to extend into another term. Leaves us without a chairman. I'm the vice chairman currently. My term expires in October, and I do not intend to come back and apply for another term. I've been on this board for probably over 10 years now. I think I did my job. Started off as a alternate for several years, and then I've been on as a full member for many years. So as of October, I'm not going to be on the board anymore. My wife and I are going to be traveling the month of August and September. So, and there's a likelihood that there won't be a meeting in July. So we want to think about electing a new board, a new set of officers. At this time, I don't know if you guys want to wait until the next meeting to do it. You could do it right now if you choose.
Mr. Chairman, first I'd like to thank you for your service, the best you could, under extremely bizarre circumstances.
We've had some pretty strange circumstances.
And also, I would like to nominate Herb Elliott for chair.
I second that.
You accept the nomination?
Reluctantly, yes, I will.
Okay, now we need one as for vice chairman.
Well, I would nominate Mr. Hrabowski.
I second that.
We have a motion and a second. Do you accept?
Yes.
He does, okay. Are there any other nominations?
No.
I don't see any no reason to vote because there's only
We're still voting anyway.
no competition. What do they call that? I forget, there's a special name for that.
Opposition.
No opposition. So I guess you two fellows are going to be the new chair and vice chair.
I think we still vote anyway. I think we still have
Yeah,
to vote
you
anyway.
can,
You think we
you
still-
can just do an all in favor. You don't have to do a roll.
Okay, all in favor of the nominations, please?
Aye.
Aye. Okay. It's done. Any other comments?
Yeah, could I? Go, Tom. You signal me.
Mr. Chairman, I also like to thank you for your service, and I wish you the best when you truly retirement and you travel. Thank you so much.
Yeah, I want to echo that. Thank you, Larry. Done a great job for 10 years. Not easy.
Although I haven't been here very long, I echo the same sentiments. Thank you.
Thank you.
I've been thinking about having this board talk about how we do things and what we do substantively and procedurally, and perhaps with an end of making a request to the City Commission for some changes, if we find it appropriate, to the Board of Adjustment. I've got a few ideas. One thing, the charter says we're supposed to have 2 alternates, and the code says 1. I think that needs to be, I think we need to have 2 alternates, because it's an important position, and sometimes we've had to continue meetings because of a lack of a quorum, and a few other things. So if you could take a look at the substantive provisions of the Land Development Code, I think it's Chapter 226 and Chapter 194 of the Land Development Code, which you can get online or at the library, and just look at it. I have some ideas. One thing says we're not supposed to consider financial factors, but I'm not going to object when I say money can't buy everything, but there are instances where if you have enough money, you can fix these problems. Like we had the one variance, which we approved last month for a 0 lot line for a fence. Well, they can tear the whole building down and redo it. So I don't think it sounds great on paper to not consider financial factors, but I think logically it can be a factor. Those are some kinds of things. If the variance tonight, they could have bought some couple of feet from somebody else next door, maybe, if they had enough money. If they had $1 million for 2 feet of your property or 1 foot, they'd probably sell it and have enough left over for the side setback so it wouldn't be in violation of the lot next door. So I think we ought to think about that and a few other things that you guys might want to discuss and have it at our next meeting or a couple of meetings afterwards. Just some thoughts that I had.
I have a few questions for staff. Mr. Hasiak, since he might not get these questions answered while he's here, I thought it would be nice. Remember what he asked you about to look into that property, the Linger Longer property sale?
Yeah, Tarpon Key. I talked to Heather the other day
Yeah,
about
Tarpon
that.
Key, and what I did was I actually found, I think this is the sidewalk waiver, and I wanted you guys to give you a copy of it and have you look at it.
Okay.
Before I go forward and try to find any additional information, I want to make sure I've got the right project, because not being here as part of that, I did listen to most of the hearing on what happened in that actual hearing, but this is, I just want to verify that this is in fact the property, so I've made copies of that Board of Adjustment notice of decision, and I'm pretty sure that that's what you're looking for. There was another one that was done in 2013 for the same property that's for a different thing, but I think this was the sidewalk waiver, and I think this is the condition that you guys were talking about.
Yeah, actually, I'm the only one that was on the board at that time that's here present.
Yeah.
So
It's Matt and you.
I guess you're just asking me that question, unless somebody was in the audience, I guess.
I watched that video.
Oh, you did?
Yes.
Okay, then you can comment. Well, I brought this question up. I want to make sure everybody knows what I'm talking about. I brought this question up last month, I guess it was. I drove, we had this request for a sidewalk variance to not put a sidewalk in a Tarpon Key along Anclo Road. And there were an awful lot of people in the audience that were opposed to it, to the waiver, right, thank you. And we had a long discussion about it. One of the reasons they wanted to do it, that waiver, was because they had a lot of trees along the road. They didn't feel it was proper to cut all those trees down. And there was also going to be some pipes and so forth that were going to have to be moved, and they didn't want to have to do that. So anyway, we came to an agreement, which is the way I like to see this board work. We had a back and forth between the board and the applicant, and it was decided that, and we would approve a sidewalk variance if the developer would put an entrance, a sidewalk entrance into his subdivision, and then allow the public to walk on his sidewalks inside the subdivision, and then exit on the other side. And that was the agreement that we came to. Sounded good to me. I drove down that road several times, and I noticed that, number one, most of the trees have been cut down, which they didn't want to cut down, so they could put a wall up. That was kind of a violation of the way we came to an agreement, although it was never written that way. And the other problem, the major problem, was that they put gates on the sidewalk. And one of the gates on the south side, southeast side, I guess you'd call that, actually has posts that go into the concrete, and you would have to walk down your sidewalk, pull those posts up, open the gates, and then go through. Inside, I can understand the part inside. All the sidewalks are not built yet, but they will be built. But to put a gate on a public sidewalk, to me, is a violation of the spirit of what we came to an agreement with them. Beside the fact that they cut down all those trees anyway, and that was one of the major reasons that they claimed that we should give them that sidewalk. So without reading all this, I think that's exactly that's my opinion of that whole deal. Yes, sir.
Well, it's very astute of you on your part to notice this, and I have some comments about that. First of all, the ordinance requires us to make findings of fact for each of our cases, and I presume that we're going to continue to do that. But this is a findings of fact order that's signed by Rodney Chapman, the former assistant planner for Matt King, and I have a problem with the staff member signing something when it should be signed by a Board of Adjustment member. And furthermore, there's nothing in this order having to do with fences or gates or trees that I see. It just says that you've got to construct a public sidewalk.
Mr. Elliott, did you watch that video?
No, I did not.
I recommend you watch it, because at the end, the most disturbing part of it was that Rodney Chapman said that he wanted to remove this whole waiver business from this board entirely. And when questioned about that, he said it was because he had so many requests from so many boards that, well, why do we have to deal with this if we have to vote for it anyway? So I doubt that a single board member ever mentioned that to him. So it's very, very well worth watching that video. It's also the video that was required viewing by the city manager to the rest of the Board of Commissioners because of what happened with Mr. Nate Tallarino and Ed Armstrong. So you will definitely want to watch that, and I would recommend that each of you that hasn't seen it watch that video.
How do you do that?
It's on YouTube.
Oh, YouTube.
So this date of this meeting, go there. You'll see that.
It's the internet, right? So,
yes,
yeah.
yes.
Well, I got a little dispute there because the chairman before Matt actually did request that.
Oh, Ed Cole did?
Yeah, but we were getting deluged with sidewalks for little 2 feet, 4 feet piece of sidewalks, and they were making them go through a the whole process.
Okay, so he did ask.
So he did actually
Okay.
mention that to Rodney, yes.
All right, well, I'm glad
That
that
was
you
many
clarified
years
that.
ago, but, yeah, and then you're right, Mr. Elliott, about the fact that this doesn't say anything about gates. But when you make a public sidewalk, you should never have a gate on it the way others.
So if,
They're
had you
actually-
been asked to sign this thing, you would have noticed that, I don't know what the motion was. The motion should have said specifically that there be no trees removed, that there be no gates, no fences, and it be a public sidewalk and public right-of-way, if that's what it was. So we got to be very clear on our motions and our findings of fact.
Particularly if you're putting conditions in there. Those should always be very clearly stated.
Who-
On this
who-
particular application too, by the way, there is a public dedication in the plats of the sidewalks, so they shouldn't be gated. So,
And what about the trees that were removed? Do we know if they applied for a,
I haven't,
Tree
I
permit?
honestly, I just really wanted to get your opinion on whether this was the right application for me to go after and the right subdivision for me to research, because you have about 3 of them from this time period that you guys were reviewing.
No, this is the one.
And I wanted to make sure I had the right one. I mean, they were all in different locations, but I wanted to make sure that we had the right one. I was clear before I went and traced the permit history, because that's going to take me some time to do.
In defense of what the board on this decision, writing this thing, who would ever think that you would have to write into this that you can't put a fence across the sidewalk? I mean, that doesn't make sense. I wouldn't think you'd have to write that kind of a thing in the motion. It'd be like, think of all the conditions you'd have to write on every single one of these things.
so since this
it
was
was
signed
public-
off on, what do we
public-
do if we go back, review the video, and it's exactly as Mr. Hasiak said, but the wrong thing was put into writing?
I defer to the city attorney's office on that, and you can think about that, Regina.
yeah,
It's gonna be
that's a rather difficult situation, but essentially, without researching it, I would say that just like the pronouncement of a judge is valid upon the judge giving it in court, it's the same way with this board, because it is a quasi-judicial board. So once you give your ruling, that's your ruling. If it's abrogated in writing, then I would say it defers to the recording that we have that says what the actual decision and order of the board was.
And what of the fact that the chair at the time, Matt King, didn't even sign this, that it was signed by staff?
The actual way that your ordinance reads is at the end of the meeting, the orders are supposed to be signed and provided to the applicants. And that has not been the practice of the board, and it's not a particularly good way to do it, especially if you are going to be granting conditions. Basically, what should happen, and this actually gets to the minutes as well, is that once you guys have your decision and then you approve the minutes, it should be issued based on your approval of the minutes. And then the order is approved at that time. Now, realistically, that would put them back another month to be able to start and do what they wanted to do, which could cause other issues. But, you know, my bigger concern with this particular one is that the board never reviewed this. The board never had the opportunity to review it, and I'm assuming that the chairman never reviewed it because he never signed it.
Right.
May I? One possible solution is to use email. Whoever prepares the orders the next day or the day after, we can have them sent to everybody by email, just as a courtesy, and say, this is the proposed order to be signed by this chairman. If
I'm
you have no
not
obje-
sure, because that could potentially constitute a sunshine law violation.
think so, no.
Yet because I know that email would
No,
be a
this
meeting
would-
and it would be taking an official action
We
at
can
a
send a
meeting.
copy to the newspaper, but I don't think it's a violation of any sunshine law.
If you, as a board, were to do it via email, it does not give the opportunity for the public to be present, and that's not a meeting that's open to the public.
The email would come from the clerk, just like we get our agendas. You know, it comes from the clerk to each of us.
But that's announcing, it's basically like doing a notice for a meeting. That's not having a meeting.
This is the proposed order. Any objections, please contact the staff clerk.
I'm still standing by that that would be a sunshine
let's-
violation. You're taking
okay.
an official action.
When we get to our rules of procedure, you may be right, I'm not saying no, but let's just, we
Well, I
got
think
to,
more importantly than that, I mean, is this a legally binding order that was signed by someone else who is not in, how could he be in position to sign that? Maybe the co-chair, right? The vice chair, but how could Mr. Chapman sign one of these orders and make that legally binding? Is it or is it not an illegal order?
At best, I would say it's questionable. And
well,
that's-
let's say, for example, it may have been a custom and practice for a month or a year ahead of time, that that's what was done. Or Matt King said to Rodney, go ahead and sign your name. We don't know all the facts yet. I can see there is a serious problem here, but we need some more facts.
Okay, so we'll find that part out. Let's say that it was illegally done. Then can we make them put the sidewalk in?
They did to put the sidewalk in. Oh,
No,
sidewalk.
all the way around
All the
the
way
property
around
the
the
way
road.
they were supposed to.
If the city did not, well, I don't want to, that's for the city attorneys to.
Yeah, I think that there's some other issues with this particular subdivision that are being researched by the city at this time, in addition to this variance. So this may be something that you hear more about in the future.
Well, I certainly hope so. I mean, if they violated what they agreed to during that meeting, then they should have to just not get the variance and have to put the sidewalk in my view.
And that's true, but you already made the, your expression that, but I think the city attorney needs to go and investigate, find all the facts before we are, because like Mr. Elliott says, we don't know exactly how did it happen, what agreement they had. So let's find all the facts first, and then we decide.
Right, I agree.
Well, further with this, I would add, I think that the findings of fact need to be part of the staff report. You need to be seeing the findings of fact that are going into these as part of your staff review and this board's review during your review of the application. So in the future, I would recommend that we look to put the findings of fact directly into the staff report. It's done in other jurisdictions. And then you are seeing the findings of fact that at least the staff's basis is recommending. Now, if you by motion decide to go away from staff, you would have to make your own findings of fact, but then they're there written, and you would have something to work from to change the findings of fact. At least it gives you a place to start from, rather than in your motion trying to address every aspect of the discussion, because that was a 2-hour meeting.
Right.
There was a lot of discussion in that, and I honestly don't know, even at the end of that meeting, if everybody in the room was clear with what actually got adopted. But at this point, you have not only this notice, but you also have the minutes that were approved by that board. So you have 2 documents that included that same condition information in that have been approved by that board. So I think that at this point, that's the document that we have to go by. Whether or not that was actually the fruit of the discussion, I can totally not tell you, because there was a lot of discussion in that meeting.
Can you answer it? Were there other documents signed by Mr. Chapman that were supposed to be signed?
Honestly, I do not know. I would have to do research on that. I saw that when I made a photocopy of them, because I just really honestly wanted to make sure I had the right property. You know, being here a month, I'm still learning my way around the city. You know, I knew a lot coming in, but still, I want to make sure I'm clear on we're going down the right trail before we spend staff time doing that, because with one staff member, I have very limited time to do extra research and go down rabbit trails. So that being the case, that was really my intention, was this is for it to be an evolving conversation, but I certainly can look into that, because I can't tell you what's been done in the past.
Sure. One quick question to the city attorney. Is the video considered to be an official record?
Yes, it is.
Okay. So you always have something to refer to?
Yes.
Well, look, I put my 2 cents into this thing.
Thank you.
My 2 cents are, I don't give a hoot one way or the other about the legal mumbo jumbo about the thing. The fact of the matter is, they put a fence across the sidewalk, and I don't think that should be allowed. And that's where I stand. Basically, this is what this paragraph on page 3 said, or page 2 says, number 1, is basically right. It's correct. But when that was written, or when that was agreed to, all that other stuff in the meeting was part of that agreement too at the same time. So this was basically left to a secretary to dig stuff out of that meeting, I suppose, and write this up. I'm not sure how these things got written up.
These got written up actually by the staff that were presenting the applications. So that's why Rodney's signature is on this, because more than likely this was, in fact, and it was his application. He presented it to this board. So in the past, that's what has been the procedure.
And beside this particular one, it makes me wonder how many other violations of these agreements we've made over the years.
That's the
I just
larger
happen to think of this one because I drive down that road quite frequently.
That's the larger issue.
Yeah.
Do the things that we vote on here actually have any meaning at all?
Right.
Or does somebody draft these things, sign them their own way? Or are we actually voting on something that is actually held accountable? Somebody's going to be held accountable.
Well, this goes back, this goes back to what Mr. Hasiak said at the last hearing that we had. The paperwork that we get, most of it is unnecessary or we're not able to read it, understand it. So if it's more explicit paperwork.
George, get to the microphone.
I'm sorry. If there's more explicit paperwork that we have, we'll be able to understand this. And since the video was made, then the secretary should be able to get the minutes right.
Any other comments?
We're lucky to have Heather.
I'm sorry?
The city is lucky to have Heather.
Well, I just think that
Yes.
if we put the findings of fact in your staff reports, you have input during the meeting time when we open it up for discussion after the public has spoken to ask the questions and make the changes that you want to see to the findings, so then the report that comes out afterwards for the notice of decision just mimics any of the conditions, if you're going with staff's recommendation, or that we're clear on the motions. And even if I have to interrupt you, that we're clear on the motions, that what you want changed is changed correctly. And I think that that's the way we need to go forward and correct the situation. And I don't know how you want to do the notice of decision. I'll leave that up to this board to decide how they want to actually do the signature, if the chairperson wants to come in or the vice chair wants to come in the day after the meeting. I mean, we can talk about the sequencing of that factor, because what I can do is notify the chair that the notice is ready for signature.
And how long does it generally take?
I did the 10 that you saw on the last meeting all the next day. That was basically, I locked myself in my office and did that.
And
So
they've been signed since?
they have not been signed because Matt was the chair, and so they went out as notice without a signature simply because we had no chair at that point.
And so,
no one could give me a clear determination on who was the signatory.
will Mr. Elliott be the signatory?
Yeah, going forward, since he's now is the chair.
I mean, even on those?
No, I guess he could sign in Matt's stead. I mean, but it's really not, he's not chairperson there. They'd have to be corrected with his signature, for his signature.
The vice chair can always sign for
So Mr. Hasiak could sign?
Yes.
Sure.
Okay. And have you ever known in any of the cities that you worked in for city staff to actually draft these documents and sign them, or has it always been done properly?
Well, generally, I mean, the last few places that I've worked, it's just been a notification letter based on what was approved in the motion, but the findings of fact were part of their staff reports. So, see, that's what I'm saying. Like, the findings of fact that are part of this document, that are an official document, were part of the official record as part of the discussion. So the motion that was happened as a result of that was clearly adopting that staff report and those findings of fact. So when that notice of decision was actually rendered, it was just a staff signature on them. It wasn't the chair's motion, because between the minutes and having those findings of fact in the actual staff report, they were covering the same things that they're trying to do here in that notice of decision. That was already covered.
Yeah, that's also exactly the reason why we proffer the staff reports and the city's file on these matters into evidence, for the purposes of the hearing, because they contain what is the findings of fact.
I mean, the findings of fact are really a summary in this
Yeah.
case of what that staff report had, but there's no reason why the staff report can't be rewritten where the findings are a separate section and are specific, so you're seeing them, and if you want to change one during that discussion time, you have the ability to do that. And I think that that's a better way to handle it.
The same thing actually goes when you're denying an application. Technically, when you deny a variance, you should be stating specifically which of the criteria, based on the facts that are presented, has not been met. And that's a finding by the board. So the person who would make the motion would say, I vote that, we deny this application because it is not the smallest variance possible to accomplish what they need, or because the condition on the property was caused by the applicant. So it's actually supposed to be specific when you deny the applications, so that there's a basis, if there's an appeal, to say this is the criteria, this was the finding of the board, they did not meet this when they presented their case.
And you can also talk to staff during your discussion period, right? So if you have concerns where you want to know exactly the proper way, based on what you're looking to accomplish, to do that and how that should be crafted in the findings, those are questions that you can ask of staff during your discussion before that motion is even floored.
All right, and
Okay.
once again, just for clarification, when we make decisions here to ensure that they're binding, who enforces those decisions? If that, not just with this case, but with anything we've ever voted on or will ever vote on, if somebody comes forward and says they violated that agreement, then what happens? Who takes?
It would go through the code enforcement process.
Okay.
So because your decisions are part of the land development code, just like my administrative decisions are part of that land development code, they go through the same process if they're violated,
Even if it's the tree ordinance? So it's fine.
even if it's the tree ordinance.
All right.
It's exactly as if it were a written ordinance of the city.
All right. The other question I have, there was a very short list of applicants for this board. We've just lost Matt. So do we have anybody on that list?
I honestly don't know. I'd have to ask the clerk what the list is and what it looks like at this point, because I don't really know that. Being this new to the city, there's a lot of things that I haven't explored, and I do have 3 other boards. So you're one of 3 that I have to find out a lot of information about.
Okay.
Could I interrupt you? As far as enforcement of our orders are concerned, the building department has a primary role to play. We want to make sure that they are notified as far as what our conditions are, so that when the permits are issued and they do the inspections, I'd like to see them, and I don't know what the procedure is now.
The process up to this point hasn't been very smooth, because some of your decisions haven't been tendered in a very, what I would call a opportune timing. They should have been done far sooner than they were. What I did with the 10 that were prepared is they are in the Navaline system, which is the city's permitting system, and the Development Services Department has access directly to those documents. So they do not have to contact us directly. That information is available to them at their computer screen. So at the touch of a button, they can open up that Your Notice of Decision, know exactly what the conditions are.
And they'll do that?
Yes, they will.
Let's hope so.
I'm not the building
Well, your
building
desk is
official,
right
but I
across.
would assume that the building official will make sure that they do that going forward.
Okay, anything else?
That's all I have.
Does staff have any comments?
That's all I
You've
have.
had enough, huh? Okay. Well, we're in order for a motion for adjournment.
So moved.
You do have one on the, there is an alternate.